oral submissions of the defense team and the prosecution, which follow the written submissions, were presented to court this week. Key points of the defense team's oral submissions include the accused party's state of mind and their reliance on the advice of professionals, as well as weaknesses in the prosecution's case. The prosecution submitted that all the accused parties intended for the church's bond transactions to be sham because there were no legal obligations on the part of the bond issuers to repay the church, and that they conspired to use the church's own money to repay debts owed to it. It pointed out that the accused were the ones who were trying to obtain funds for Extron to repay the church. In facilitating this, the prosecution emphasized Extron's purported lack of independence and how it was controlled by Kong Hee and Tan Yee-ping. Additionally, the prosecution submitted that the accused misled the Baker Tilly auditors, using them as a cover for their conspiracy to misuse church funds to finance the crossover project. They submitted that Kong was happy to outwardly seek the support of the lawyers and auditors, but did not want them to scrutinize the transactions. Quoting past cases where other religious persons had caused wrongful loss to their organization, the prosecutor said that it was a fallacy that someone motivated by religious aims could not be dishonest. She also submitted that it is irrelevant that the misappropriation of funds was done to further the church's mission, and that the ends did not justify the means. Senior counsel Kenneth Tan, defense lawyer for John Lam, stated that the prosecution had to prove beyond reasonable doubt that the bonds were sham in nature and that his client knew of the sham nature and agreed to the conspiracy. Tan pointed out that there had been no direct evidence pointing to his client's knowledge of the sham nature of the bonds. All the prosecution could rely on was its own inferences that Lam knew about the plans. Tan concluded his submission by stating that the prosecution cannot simply join the dots when there is no direct evidence showing that his client had knowledge of the sham nature of the bonds and had agreed to participate in the alleged conspiracy. In closing, Tan told the court that John Lam doesn't know the facts which would constitute these bonds being shams. It's now the close of a very long trial. Now I can say the prosecution needs to join those dots by inexorable and irresistible inferences. It can't do that because John Lam is not guilty of any of the three charges, sir. Following Tan, Kong Hee's lawyer Jason Chan submitted that evidence before the court had in fact showed that what happened was the complete opposite of the prosecution's case. Kong's state of mind had always been that it was legal to invest the church's building fund to support the crossover project. Chan told the court that Kong repeatedly gave instructions to his team to seek advice from the church's lawyers and auditors before executing the transactions, and evidence showed that his instructions had been carried out. Chan noted that it went against logic that a person with dishonest intent would bring his plans to advisors. He also noted that these advisors had never told Kong that the building fund could not be invested and used to support the crossover project. Chan ended his closing submissions by saying, "Putting all of that together, looking at the actual evidence before this court, our submission is that it is unfair to say that Pastor Kong and the other accused were dishonest. It is equally unfair to say that they intended to enter into anything that could be called a sham transaction. Under the circumstances, Your Honor, it would be unfair to convict Pastor Kong and the other co-accused of the charges concerning the subscription of the bonds." In his closing submissions, Paul Seah, defense lawyer for Sharon Tan, focused on Tan's lack of motive and her mindset while carrying out the transactions. While the prosecution had argued that there was no need for a motive as long as an illegal act was done, Seah reminded the court that motive has always been a key part of the court's consideration on criminal cases. Seah pointed out that the prosecution had disputed the timing of the handwritten notes by Sharon Tan that the Commercial Affairs Department had seized. He said that the notes were so detailed that there was no other conclusion to draw except that they were contemporaneously produced during the board meeting. Seah noted that it is not the normal behavior of criminal conspirators to go to the board of the organization that they are seeking to cause loss to, then proceed to draw complicated diagrams and explain to them step by step in detail exactly how they are going to go about the criminal scheme. Yet, this is exactly what Mr. Chu and Pastor Tan did, and Ms. Tan went along happily, taking minutes. He added, "Your Honor, this is not criminal behavior, or if it is, These must be the most absolutely inept, irrational criminals I've ever seen. Former fund manager Chu Eng Han, representing himself, reiterated that his frame of mind had been pure when he was alleged to have conspired with the other co-accused to commit criminal breach of trust. He submitted that the bonds he had structured as investment manager of the church were in line with common market practices. The prosecution's argument that the lack of negotiations and failure to redeem the bonds within the maturity period meant that the bonds were sham was a redefinition of investment rules according to real market practices. He added that if the prosecution was correct, the implications for the whole financial industry would have been disastrous, as nobody would dare issue bonds anymore. Chu questioned why the prosecution did not call in any expert witnesses if there was such reliance on the technicalities of what constituted a sham bond. He submitted the prosecution should not have quibbled with the structure of the bonds, but the career and track record of San Ho, which he claimed he had been misled to believe to be a real success. Tan Yu Ping's lawyer, senior counsel N. Srinivasan, presented the court with a list of 39 points arguing against the prosecution's written submissions. He took the court through some of these, opening with a statement that the CHC case was unique in that it had no complainant, there was no expert evidence heard, and both sides agree opinion evidence could not be considered. And what was also unique was the relationship the accused had. Regarding the prosecution's charge that accounting records had been falsified, Srinivasan pointed out that there were only two other options: to not have recorded anything at all, which would have been just as wrong, or to record the transactions in question as something else. Strangely, the prosecution had, to date, never stated what the right accounting entry should have been. Over the course of the trial proceedings, the court has also heard the prosecution insisting that the accused parties were lying when they said that the church's board members were misled about the bond transactions. The burden of proof was then on the prosecution to produce witnesses from among the board members to testify so, and the prosecution cannot simply assert its disbelief of the accused party's testimony to make its case. The senior counsel noted, however, that the prosecution had not called any board member. Srinivasan closed by exhorting the court to look at what they did prior to the bonds, the manner in which they did the bonds, their conduct after that in trying to get the money back in. If we look at the emails they exchanged with each other contemporaneously, they were not talking about something that was sham. Rounding up the defense team's submissions, senior counsel for Serena v. Andre Maniam said that the CHC case was an odd conspiracy because guilty parties typically attempt to escape liability and not take on liability. This was in response to the prosecution's position that the bonds were sham because the accused knew Extron would not be able to recoup its investments, and instead of letting Extron find solutions by itself to fulfill its debt to CHC, the accused were themselves helping to ensure the fulfillment of the bond obligations. It's just not human nature for someone to know they would lose money but then take on the liability themselves. In addressing the sham allegations of the bond transactions, Maniam quoted illustrations from two cases where the court ruled that it was not enough to ask if the accused knew that they were doing wrong, but if they actually committed wrongdoing in order to cause wrongful loss. In the case of CHC, said Maniam, there was insufficient evidence of this wrongdoing. District Judge C. Ki Un will deliver his judgment on 21st of October. For more information, please log on to citynews.sg. I'm Sandy Yeoh for City News, Singapore.